To start with, I would like to acknowledge the traditional custodians of the land that we meet on today and their continuing connection to land, culture and community. We pay our respects to elders past, present and future. IMAW was created to showcase mediation taking place across the world. The Mediation Network team has set out to encourage more engagement with this form of dispute resolution by using this week and activities throughout the year to promote mediation at an international and regional level. We are working with a growing number of organisations and individuals to bring you IMAW and are delighted that we are joined by some amazing and passionate individuals who help make this a success. This week is brought to you and managed by Mediator Network in collaboration with our global partners and regional coordinators. I'm Tracy Wheat and I shall be your session host and will be introducing your speaker shortly. Before I do, I need to remind you of some house rules. Firstly, the session will be recorded, so please turn off your camera and audio. There will be a question and answer session at the end, so please put your questions in the chat box and we can go through these at the end of the presentation. If you drop out of the session, please log back in and I will let you back into the session. So I'm delighted to introduce you to Jessica Kastoun, and she'll be talking you through today's session. Jessica is a lawyer, mediator and FDR practitioner and a consultant with specialty in government and public services. Thank you, Jessica.
Thank you, Tracy, for the introduction, and good afternoon to everyone on the call and whoever's watching us on the recording. Welcome to the International Mediation Awareness Week's public webinar. I'm Jessica Kastoun from Jessica Adele Consulting Services, and today I'm speaking to you from the traditional lands of the Camaragal people in Sydney, Australia. A welcome to you from wherever you are around the world. Please feel free to type in the chat box which state or country you're tuning in from. Today, I'm looking forward to providing you with some information about the advantages of mediation and the circumstances for when mediation does not work or is not appropriate. And then I'll briefly provide you with a consideration of other alternative dispute resolution processes. Tracy, can I just check that you can see my screen clearly?
Yes, we can. Thank you.
Okay, great. So here's a quick snapshot of what we will be covering today. So the overview is, we'll look at what's in this webinar for you, why listen today, what exactly is mediation and what types of disputes can be mediated, how does it work, and what are the benefits and strengths of mediation. We'll also look at the circumstances for when a mediation is not appropriate or might not work for you or might not be successful. And we'll also consider other forms of ADR. ADR, I'll be referring to it in the acronym. It's a short form for Alternative Dispute Resolution. And if you stay towards the end of the webinar, I'll gift you a free gift from Jessica Adele Consulting Services. All right, so who's this webinar for? Basically, if you're feeling conflicted, agitated, discomfort, or overwhelmed in some area in your life, and you found yourself in a dispute, your problems can be managed and even resolved through mediation. Perhaps you're currently in a dispute with another business, a customer, an organization, a service provider, a corporation, or government agency. Or perhaps you have a complaint about a person, an entity, a service provider, a workplace, or a government agency. Perhaps you're in a dispute with your current or former partner, or a family member, or a neighbor, or a community group. Maybe someone has taken legal action against you and you're not quite sure where to start. Well, I'm here to tell you that mediation might just be the right procedure for you. We'll go on to the next slide. So mediation is one type of ADR. What is ADR? It's basically all the alternative ways of resolving conflict outside of the remit of the traditional court system. ADR processes do not include judicial determinations like court or tribunal decisions. And today I'll briefly look at the other alternative ADR pathways, which include negotiation, conciliation, collaborative law, arbitration, E&E, and expert determination. So I have there on the board two definitions of mediation. One is from the Singapore Convention, which has 55 signatories currently, I believe. And the other one's from the American Bar Association. I prefer the ABA definition there. So it says, mediation is a private process where a neutral third party called a mediator helps the parties discuss and try to resolve the dispute. The parties have the opportunity to describe the issues, discuss their interests and understandings and feelings, and provide each other with information and explore ideas for the resolution of the dispute. So what does that mean in general terms? It means mediation is a structured process where uncomfortable conversations between opposing parties are discussed with the mediator as the conduit guiding those discussions between the parties, with the primary objective of problem solving and resolving the dispute. It's very important to remember that mediators do not judge or arbitrate the dispute. They advise and consult impartially with the parties to assist in bringing about a mutually agreeable outcome. Okay, so depending on the problem at hand, the mediator will apply a particular model of mediation or a combination thereof. Mediation can be transformative, the style could be facilitative, or evaluative and advisory. Evaluative and advisory is more in the conciliation type of mediations. So there's various styles that can be applied by the mediator. Mediation can be voluntary, it can be court-ordered, or required as part of a contract. In Australia and overseas, mediation has gained a rising popularity in practice over the past 30 years, and it will continue to grow because of its many benefits to disputants. And also, in light of the COVID-19 lockdowns, you can see there's been an increasing trend in resolving disputes online by remote access, and that has seen the efficiency of online mediation. In most Australian jurisdictions, the courts have the power to order parties to a mediation or require them to engage in some form of ADR process. And that has been enabled by the legislative reforms in Australia. Let's say, if you look at the family law context, for instance, you have the Family Law Act 1975. Those changes in the law reforms that came about, I think in 2006, made family mediation, FDR, compulsory as a first step before commencing any court proceedings, unless there's an exemption. Okay, moving to the next slide. So what are the type of disputes that can be mediated? You can see there on the slide, I have several types of industries and sectors there outlined. So you have civil and administrative matters that can be mediated, family disputes, neighborhood disputes, commercial disputes, financial services, tenancy and property disputes, construction, planning and environmental disputes, privacy disputes, IP disputes, workplace disputes, human rights disputes, telco disputes, and also international disputes. So if you have a dispute around a boundary, a territory, or land dispute between countries, or even in peacekeeping operations, mediation can be applied. And it's also applied in reconciliation commissions as well. So you can see there, the list is expansive. And I hope you get the gist there that you see that the complexity of the case or the number of parties is no bar to attempting a mediation. It's about finding the rightly skilled mediation for you with the relevant expertise to help you work through your problem. Okay, so what is the success rate? Well, if we look at the stats in 2018 to 2019's financial year, in Australia, 72% of matters were resolved prior to trial by court-referred mediation in the form of Federal Circuit Court of Australia. This court has now combined the family law jurisdiction and it has been renamed. Also, if you look at the US jurisdiction, commentators say that mediation works in settling over 85% of the cases in which it's used. That's including where the parties have been unable or unwilling to participate in the first instance. All right, so how does mediation work? Well, normally there's three main phases to the mediation procedure. You have the pre-mediation, which is the preliminary conference. That's where the mediator and the client have a discussion, and it's for the mediator essentially to gather information, understand the case, and assess the suitability of the matter for mediation. And also, if it's suitable, get agreement from each party to prepare for the mediation. And then if the mediation is going to go ahead, you have the joint session. Usually in my experience, it's capped at 3 hours in the conciliation setting, and also in family child parenting disputes, 3 hours as well. But you have, say, where there's perhaps more complex disputes, say with property disputes, that can go up to 7 hours or 6 hours. It just depends on what the parties agree to with the mediator. And you also have some mediations that extend over several days, weeks. And I've included there the post-mediation phase, which is essentially about the parties executing the agreement and also complying with the outcome. But it's very important to note that mediators do not enforce an outcome, not even do conciliators do that. It's up to the parties to enforce it. But what parties can do in the mediation and the heads of agreement, they can include a clause to say, we'd like to return to a mediation at a later date, or renegotiate, revise, or reconsider. So that can be done. There's also an additional type of service that can be provided by some mediators who trained in conflict coaching, and it's to have a mediator have a type of conflict coaching with a client post the mediation. And that's usually in the workplace and relationship type of disputes to sort of help that party manage an unresolved situation or a difficult relationship. So that's an additional service. All right, you can see there on the screen that gentleman is there sitting in the comfort of his own home. So this screen sort of gives you an idea that mediation can be conducted online, which is usually how I conduct my mediations, and I believe most mediators in this webinar conduct it online. But it can be also conducted face-to-face, and it just depends on the service provider, and what the parties are comfortable with. But online, it can be conducted over Zoom, over WebEx. It depends on the mediator's technology. And also, say, in family property mediations, I use the Legal Tech platform by the creator Fiona Kirkman. You would have heard about her. I believe she was discussing the family property legal tech earlier on today. So you can see also in the screen, besides face-to-face or completely online over Zoom, you can have a hybrid type of model where some people are sitting in one room, the mediator's in another room, and the other parties are in another room, or overseas or domestic. So that all can be worked around thanks to technology. What I have there on the screen is the ideal mediation process. And they're the phases that usually the mediation procedure goes through. I won't go through that in detail, but that usually is discussed between the mediator and the clients in the first phone consult. It basically gives you an idea about how structured the mediation process is, what the stages are, what it includes in terms of opening statements, looking at drafting the agenda, exploring the issues, etc. Like I said, I won't go through that because we're limited with our time here. But that gives you an idea that it is a structured process. All right, so let's go into the important part for why we're all here today. What exactly are the benefits and strengths of mediation? So when both parties are willing to participate in mediation, several benefits are apparent. Disputes can be resolved way faster in mediation compared to lengthy litigation and judicial processes. It can also save you so much money, because mediation is so much cheaper than formal court proceedings and expensive litigation and paying for legal fees. In mediation, you do not require legal representation within the mediation, so that saves you costs of lawyers and barristers. But as mediators, we do advise parties to seek legal advice prior to attending the mediation. Another benefit that's really well documented is the client's satisfaction with the outcomes of the mediation. So what's the level of satisfaction there? Parties usually feel satisfied because they have this high level of control over how the dispute is settled, because they're in charge of the outcomes. You're making the decisions about what works for you rather than having the court reach an outcome that perhaps won't necessarily, the legal facts and the law won't necessarily fit to your scenario, or only fit part of your scenario. In this context, say you have a relationship problem, or an issue with how the law is interpreted, or perhaps you'd like a change with a rule, procedure, policy, or governance within an organization or an entity. All of that can be negotiated around and can be discussed, and creative outcomes can be reached by both parties. So because of that type of negotiating between both parties, you have control, as I said, so it's more self-determination, and because it's self-determination process, there's more empowerment. You feel empowered in the process. As I said, the outcomes, you can decide whatever both parties agree to, so you can be as innovative as you want to be, and because of that, it is a win-win solution for both parties. So also because your wants and needs might not necessarily be a legal outcome, maybe it's not even financial. Maybe you're just seeking a written apology or a verbal apology, and that's something you can have in mediation. Perhaps you're seeking an amendment to a policy, a practice, or procedure. That's also something you can negotiate around in mediation. So I also have there on the screen the flexibility with how the settlement agreements are drafted and formalized. There's a lot of flexibility around that. You can come to agreement in terms of a heads of agreements. You can formalize that. You can turn it into court orders or a deed of settlement, or say with parenting plans, a lot of parents just leave it at that, and they're happy to go with the good faith agreement. I'll just move on to the next slide. There's more there. So we know that mediation enjoys a high rate of success, but even when a matter does not resolve or settle at mediation, it's common for a settlement to be reached post-mediation, before the matter proceeds to trial. So essentially, mediation assists both parties in narrowing the issues in dispute, and it can be a catalyst for subsequent settlement. That's why mediation is really great for exploring issues and opening up those conversations, especially where there was no conversation to start with. Another benefit with mediation, it's the informal atmosphere and the non-adversarial setting, which clients say they feel comfortable because they're less intimidated as opposed to court proceedings and court settings, which are more formal. And also it's less stressful overall because you're actually negotiating, you're doing something about reaching resolution, you're doing something around it rather than waiting for years or a prolonged court decision. So you're not living in prolonged worry or uncertainty until a court decision is made. You're actually attempting to do something about the problem you're faced with. Another benefit is mediation is confidential and it's private. So that's very important for parties. And also what's discussed in mediation is inadmissible as evidence in court proceedings or other judicial proceedings, except in certain circumstances. So the mediator has to ensure that confidentiality is limited in circumstances where there's a need to prevent a serious threat of harm to someone's life, or say there's child abuse or commission of crime, then the mediator has reporting obligations there. Safety is another big benefit. A lot of parties report saying they feel safe conducting mediation online because they're in the comfort of their own home, their own environment. They're not necessarily near the other party where emotions can get really elevated. That's especially in domestic violence types of context or other scenarios as well. Also with the rise in COVID, some people say that they feel safer conducting the mediation online rather than living around the stress of contracting COVID or any other types of illnesses. What I have there on the screen also, there's if there's a need for parties to find ways to preserve and maintain the relationship, mediation works really well for that, or to even restore, repair, or rebuild their relationship. And that could be a personal or commercial relationship. I myself, I've heard a lot of parties saying, even though the mediation hasn't resolved, they say thank you. This has been a great opportunity because I've been heard by the other party. And it sometimes proves to be very healing and therapeutic for parties as well, especially say in the conciliation context, say where the party wasn't heard in the first instance by an agency or a government. So as I said, where there's a need for parties to preserve their relationship and remain on good terms, that's mediation is important for that. And also, if there's a need to stay working together, stay in a work context, or a need to maintain that relationship, you'll notice an improved type of communication following the mediation. So it can sort of assist with dispute prevention as well, because both parties are understanding each other. And say if you have any cultural barriers, or a party wasn't able to understand where the other party's coming from, and say there were issues there around the cultural beliefs or systems, that can be unpacked and uncovered. And because of that, you're able to prevent disputes from happening in the future. I'll just move quickly to the next slide. That basically shows you there where mediation improves communication and understanding of other parties. So if you look at the big circle there, it says what I think, and then looking in there is what I can put into words, and then what I say to other people, and in the small circles actually what people actually understand. So really mediation helps bridging those gaps and those bridges there. Okay, where was I? So finality of the settlement agreements. Basically, because both parties are agreeing to the settlement, then that's a benefit, because there you have an agreement and it's enforceable by contract law. I think I mentioned earlier around enforceability of the settlement agreements. They're enforced under contract law, and also some parties could choose, with the assistance of their lawyer, to turn the heads of agreement into a deed of settlement to make it more of a formal agreement, or even into consent orders, and that's used in several settings, also in the family law as well. But as I said, there are parents and couples who just are happy to keep the agreement in good faith as it is without formalizing it further. All right, so what are the circumstances where mediation is not appropriate? There's some situations where, say you have that first phone call with the mediator in the intake call. That's where the mediator assesses the suitability of the case, and that's where it's uncovered whether or not the matter is suitable. So if it's clear to the mediator that both parties or a party is unwilling to participate in the mediation, or say they just outright refuse, they have a negative mindset about the process or the other party, or even negotiating or compromising, or they're very stuck in their position, then mediation wouldn't be suitable. Or if you have a case where a party keeps just postponing their availability, that shows there's no clear commitment to mediate. So essentially, it's very important for both parties to understand when you're attempting mediation, the goal is to make a genuine attempt to mediate, which means to understand the other party and attempt to compromise. Your matter might not be suitable for mediation if it's clear that there's evidence or risk of family violence, or if there's child abuse or criminal or illegal activity. And in those circumstances, say as an FDRP myself, I'd have an obligation to issue a Section 60I certificate. And that will be given to the party for the matter to proceed to the next step within the legal process. Sometimes if there's evidence of big power imbalances between the parties and that cannot be managed, then sometimes it's just not suitable, because there could be a situation where we really want to try to avoid turning this amazing tool of conflict resolution into a traumatic experience. But that's where the skill set of the mediator is, to try to work around whether the matter is suitable and whether there's different strategies that can be put in place to work around those imbalances. Now, if you have an urgent matter that needs to be dealt with, say you need an injunction or you need a decision from the court, then mediation is not suitable. So say your child is perhaps at risk of abduction to a non-Hague Convention country, then that's where it's quite essential to proceed to the next step. You'll be issued with a Section 60I. But then again, it could be the case that if a party is in another country already with your child and they're willing to at least have that phone call or attempt a mediation, you could benefit from the process. So it's up to you to weigh it up there. I put there on the screen situations where mediation might not be successful. Say parties don't wish for the case to remain confidential. Maybe a party wants to set a precedent, then mediation is not suitable for that. Also, when the authority to make the decision is absent from the negotiations and is not being informed or is completely unaware, then that's going to unravel the outcome. So it's quite important to have that authority, that decision maker present in the mediation. They don't have to physically be present, but at least kept in the loop of what's happening. So that could be in a big government setting, a big entity, a telco, a big organization, where you need to go up that hierarchy. If parties are not acting in good faith, then that would unravel the mediation as well. Also, mediation might not be successful if full and frank disclosure is not upheld. Or maybe parties are just too far apart on some issues. That's not to say you shouldn't attempt mediation. Of course, that's the place to try to work through the problems. But if you're stuck in your position and you're just not willing to understand the other party, then mediations will unlikely be successful. There also could be conditions where an issue is being dealt with in another jurisdiction, and that needs to be resolved first before the mediation happens. So I'll just give an example. Say when I was in the Privacy Commissioner, there could be two matters being dealt with, say with the Australian Human Rights Commission about the same complainant, about the same dispute, and also with the Fair Work Ombudsman. So there's issues there that need to be settled first before the matter is dealt with in the jurisdiction that I was looking at. That's just an example. All right, how are we going with time? All right, looks that what do I have there on the board? I have, what are the other forms of dispute resolution that we could consider? So I just pitched to you the benefits of mediation, and just the point that I really want to make here is you can attempt mediation at any point between those alternative dispute resolution procedures, the other ones. So it doesn't have to be after negotiation. It can be before, after, or it can be after collaborative law or arbitration, after you attempt another procedure. It's just how willing and open you are to attempting and negotiating. So negotiation there can be direct negotiation between you and the other party. If that works here, communication is key. But if it works, good on you. You don't need to go to the next step, which is legally facilitated negotiations. And I say the next step, that's not necessarily the next step. You can go to mediation after attempting direct negotiations without seeking assistance of a lawyer. The other one I have there on the screen is conciliation, which involves, it's very similar to mediation. It involves a neutral third party, the conciliator, who makes suggestions to the parties, and those suggestions are more evaluative or advisory type of information that the conciliator is providing, and that's based on the conciliator's knowledge of the law and within the setting. So it could be within a tribunal, a commissioner, or a government agency. So they sort of give the parties that insight into their options. But then again, in conciliation, the conciliator can suggest a solution, but he or she cannot impose one on the parties, like with the arbitration procedure. The benefits of conciliation, it's shown that it can really improve the relationship between disputing parties, where there is also a need to preserve a relationship, or even in a workplace context. It works as well in workplace disputes and for separating parents as well, where there's some need to maintain a transactional relationship, and if they're looking after children. We also have there on the screen collaborative law, which is a unique form of ADR, mainly in the family law divorce context, whereby parties agree at the outset not to go to court to litigate and work towards a mutually acceptable settlement. Here, separating couples are represented by collaborative family lawyers who work together as a team. But note that the collaborative lawyer is not a neutral party, but an advocate for their client. So how is it different to an FDR, a family dispute resolution process, or the role of an FDRP? Well, an FDRP must stay impartial and they cannot offer parties any legal opinion or advice or favor one party's position over the other. But in the collaborative law context, it would be more suitable for clients who say they feel they prefer additional guidance from a lawyer throughout the process. And it's best for separating couples who don't feel competent enough to negotiate alone without that extra support around financial issues or child-related issues. Okay, so I think this is my last, just check, yeah, it's my last slide. Whoops, let's go back. Arbitration. What is arbitration? It involves an independent third party who makes suggestions and imposes a decision, which is an award, on the parties after there has been a presentation of evidence based on the applicable law. Here, the arbitrator hears the merits of both sides, then makes a final binding decision. So arbitration is commonly used in industrial disputes and other types of disputes, but basically the arbitrator is an expert in a subject matter and their specialty is in that field. They could be a retired judge or a senior counsel. So you consider arbitration when you want decisions that are legally binding on the parties, and both parties have to accept that arbitrator that you're nominating. And the benefits of it is that arbitration offers parties a lot of privacy. It can also offer remedies that the court can't, but arbitration can be expensive. And sometimes the decisions, well, most of the times, decisions arbitrated can be more win-lose scenario rather than in mediation, which is more win-win for both. And the right to appeal decisions by an arbitrator is very limited. Arbitration is also not always the quickest dispute resolution procedure. So I sort of said that mediation is more interest-based. It's more about the parties, but in arbitration, it's more right-based. So in mediation, you're negotiating with the other side, but in arbitration, your role is to try to convince the arbitrator of your case. Sometimes mediation can be combined with arbitration if that's agreed to from the start in a contract. Say, if mediation doesn't settle within a time frame, within a period, or if a party refuses to participate in mediation, then it can go directly to a binding decision by an arbitrator. I also have there on the screen early neutral evaluation, which is another ADR model in which the parties to a dispute present arguments and evidence to a dispute resolution practitioner, who is usually a judge, a judicial officer, a tribunal member, or like a senior lawyer, and they sort of do a SWOT analysis of the case in an attempt to resolve the matter at an early stage of the dispute. So unlike mediation with E&E, the court proceedings have already commenced. Litigation has commenced. That's the standing point here. So the practitioner in this context makes a non-binding evaluation of the case, which is a likely outcome if the parties go to trial on the main key issues in dispute, and the most effective and the dispute resolution practitioner gives the parties an idea about what's their best options there without determining the facts of the dispute. E&E is common in construction disputes. Normally the evaluator there is a senior counsel, or they have a specialty in an area of law. E&E is also found in federal court cases, like in the native title cases. What are the benefits of E&E? You basically get the benefit of obtaining a judge's opinion or a senior counsel's opinion about the merits, the claims and defense of your matter, which sort of forces the parties to get a reality check of of their dispute and try to maybe go back to mediation or try to pick another dispute resolution before going to trial. So they get a really valuable opinion by that expert. The last one that I have there on the screen is expert determination. And that's usually a process that's founded in contract, in which the parties to a dispute present arguments and evidence to a dispute resolution practitioner who is chosen based on their specialist qualification or experience in the subject matter of the dispute. And that person is known as an expert, and they make a determination. So in this process, there's no right of appeal, and the expert's determination is final and binding on the parties, save in the except in cases where, say, there's fraud or it manifested an error, a type of administrative error. And the type of disputes that expert determination is used in is around valuation or rent reviews or share valuations, or even more technical disputes. It could be an IT, accountancy disputes, supply of contracts, oil and gas types of disputes. I think we powered through this. So for those of you who stayed with me on the call, thank you for that. I will provide you with a free gift, which is a mediation preparation guide. So if you're interested in proceeding to the next step, if you have a dispute that you're going through and you feel that you might benefit from the mediation process, or you'd like to have a phone call with myself or any other mediators, I think this guide will be very helpful for you. So I'll just copy paste that link into the chat box. I'll exit my screen, and Tracy, I'll hand it over to you for questions while I copy paste that.
Thank you, Jessica, for that wonderful presentation. Does anyone have any questions? If you want to pop them into the chat box and we can ask Jessica.
Great, and I just posted the link there.
Sure.
Oh, great. We have people from Peninsula, from Victoria. That's Leonie. Leonie's from Victoria. Welcome to you, Leonie. Welcome, Kishore, from New Delhi. Oh, that's awesome. And from
international participants. So thank you very much for joining us. Jessica, a question. When parties are unwilling to participate, do you try to encourage them to engage or accept their initial position?
Okay, so my practice is I try to understand why exactly they're unwilling to participate. What are the blocks around that? Is it around a belief or an actual legal problem? I try to unpack that with the party, have that discussion first, and then, if appropriate, I do encourage them to attempt dispute resolution. So I'm the type of mediator that's really hones in, and I advocate for dispute resolution when it's appropriate. But it's very important to have that discussion first and give parties a clear indication of their other options besides mediation.
Okay. Another question. Do hybrid modes of dispute resolution like mediation, arbitration, mediation conflict with each other?
Okay, thank you for your question, Kishore. I don't think they do. From what I know, you can, within a contract, make a clause that says you start with mediation or you attempt it within a certain time frame, and if you don't, the matter automatically goes into arbitration. So it just depends on how that's worked into a clause. And also, if we take a step back from arbitration, if you're looking, say, in a tribunal setting, or in a commissioner setting where the equivalent is a determination needs to be made by an officer, usually there's also consideration for the first step is a dispute resolution type. If that's not resolved, then you go into the determination step. So even an arbitrator would look at that. They look to see if you've attempted mediation or any other forms of dispute resolution. So no, I don't think they conflict at all.
Thank you. Did that answer your question, Kishore?
Oh, thank you for that, Louise.
Yeah,
I appreciate that.
Yeah, thank you. But I also see have some additional question.
Yes,
Does
go
it
ahead.
affect, looking at this issue from the perspective of the parties to the dispute? So is there an additional cost if there is multiple modes of dispute resolution. So do they add to the cost?
Okay, so you cut off at the beginning of what you said, but I got the gist of what you're saying. If it costs additionally, if you're adding all these types of dispute resolution, is that what you're saying, Kishore?
Yeah.
Yeah. So from what I've seen, and okay, you could look at it. Are you looking at it in terms of cost of a private practitioner? If you are looking at it in terms of, so the way I see it, I think any type of dispute resolution is cheaper. Providing that as a service in the first instance is a good option for clients to attempt before going into the more binding types of dispute resolution. So arbitrations after, litigations after. There's never a financial loss if you attempt mediation. Now, there could be a thing where one practitioner, one dispute resolution practitioner charges way more than another private mediator, and then that's upon the client to go find the appropriate service provider. That's also not to say that you can't find, in the family law context, you can't find the mediators operating within a scheme. So say you go to organizations like Relationship Australia, you can have a mediator who's funded within an organization. But to summarize, no, I always think it's cheaper to attempt dispute resolution 100%, in Australia at least.
One more question, like you see the disputes, especially commercial disputes or IPR disputes. So parties are usually reluctant. They prefer either litigation or arbitration. So after the Singapore Convention, so what is your analysis? That is there any likelihood that mediation would be popular even in commercial disputes or IPR disputes?
Yeah. So I know mediation is used a lot in type of commercial type of disputes and intellectual property. However, it depends on how it's set in contracts. So usually when those contracts are made in those settings with IP, you have to go back to the original contract. It could be that arbitration is the first step that you need to attempt. So you just need to go back to the source, but there could be clauses that say parties can attempt mediation first, or they have to go to arbitration first. It just depends on the source of the law. But I know from experience, say, overseas in some Middle Eastern countries, they really rely on mediation for, in the Middle East, for intellectual property and commercial matters. They rely on that because that sort of helps them go through these types of dispute resolution and not be limited to the legal setting that they're in within a country if it's a more type of international dispute.
One more question, actually, final question. Like you see, is there a sequence or the order, like if you see we're having a hybrid method, so whether mediation should be first or arbitration should be first? So is there any kind of international legal requirement? Because when it comes to enforceability, so whether it will become a problem. So what should come first?
Okay, so as I said, you go back to the source. The source is the contract. If the contract says parties can attempt mediation first, then you attempt mediation. If mediation is not settled within, say, 15 days, that's in the clause of the contract, then parties must go to arbitration, or they must go to E&E or another type of determination. So that's actually written in the contract between both parties. But generally, mediation, so negotiation is the first step, and then mediation is offered as the second step. Like that's what the service is about, to try to get people outside of going to the court jurisdictions and those settings where parties don't have power to make decisions.
Thank you for all your questions. I am being mindful of the time. Sorry to cut you off, Kisha. So thank you for attending today's session. We want to say a huge thank you to Mediator Network, Mediation Institute, our sponsors, collaborators and volunteers who have contributed to make this week a success. So we encourage you to book online through our portal. I've just posted the link in the chat box. So please register for some more sessions and make sure you book onto the global debate, which is being chaired by Jonathan Lux. This will be an interesting discussion on whether the Western model of mediation is fit for a multicultural society. We'll be joined by representatives from all over the world. So I hope you enjoy the rest of the week and the sessions that we have. Thank you for joining us.